Welcome to the deep dive. Today we're heading back, way back, to the early 1900s. Now picture this. Cars are just appearing, but they're nothing like what you drive today. They're noisy, they break down all the time, and honestly, they cost a fortune. Seriously, these things were toys, pure status symbols for the incredibly rich. Your average American family, still getting around with horses. But over in Detroit, there's this one mechanic, a guy named Henry Ford, who sees things well, differently. He's not dreaming about fancy cars for millionaires. No, he imagines a car that's simple, tough, and, crucially, cheap enough for everyone to own. A car for the working man, the farmer, the regular family. But there's a huge roadblock, a really powerful group called the Association of Licensed Automobile Manufacturers, a LAM for short. Think of them as a cartel. And they have this patent, right? And they claim it gives them total control over every single car being made in the U.S.
Yeah, and that's what makes this such a fantastic deep dive subject. This isn't just some dusty legal case about patents. It's a classic David versus Goliath story, You've got this lone inventor, Henry Ford, going up against this massive, entrenched monopoly. And the outcome? Well, it didn't just change cars. It arguably changed the whole direction of American industry. It really set the stage for how we think about innovation versus market control.
Absolutely. So our mission today is to really unpack this fight. Who were the main players? What exactly was at stake? And what's the lasting impact for you, for all of us, when it comes to making new technology available to everyone? Because those echoes are still felt today. Okay, so to really get a handle on what Ford was up against, we need to back up just a little bit, because the whole thing didn't start with Ford. It actually starts with this lawyer, George B. Selden, over in Rochester, New York. And calling him an inventor might be a stretch. Clever opportunist feels closer to the mark.
That's putting it mildly, maybe. Get this. Back in 1879, Selden files a patent for a road engine using an internal combustion engine. But here's the kicker. He doesn't actually build one. Not a working one, anyway. Instead, he plays this incredible waiting game. For 16 years, he keeps amending the application, just keeping it alive, delaying the final grant.
16 years!
Yeah. He waits until 1895, right when other people, actual engineers and mechanics, are finally making automobiles practical. Then his patent gets granted.
So, wait. He basically patented the idea of a car without building one and then just waited for everyone else to figure it out.
Pretty much. He claimed he'd invented the automobile itself. It's audacious, really.
How could the patent system even allow that? I mean, delaying for that long while the technology races ahead?
It really highlights a tricky part of patent law, doesn't it? That tension between rewarding invention and preventing someone from just squatting on an idea.
Yeah.
Selden basically used loopholes. He kept filing amendments, minor changes, which kept resetting the clock on the review process. It kept his claim active while the real development happened elsewhere.
Okay, so he gets the patent in 1895. How does that turn into this all-powerful alum monopoly?
Well, a company called the Electric Vehicle Company saw the potential. They bought Selden's patent rights. Smart move, financially speaking. Then they formed ALUM, the Association of Licensed Automobile Manufacturers. And their business plan was brutally effective.
Which was?
Simple. You want to build a car with a gasoline engine,
Yeah.
you pay us a hefty royalty on every single one.
And if you didn't?
They'd sue you into oblivion. They threatened everyone. It raises that big question, right? Are patents protecting inventors or just gatekeeping, stopping competition?
Right. So that's the landscape. Alum has this iron grip thanks to Selden's delayed patent. Then comes Henry Ford. And remember, by 1903, Ford wasn't exactly a success story. He'd already failed twice in the car business. Most folks probably just saw him as, another tinkerer who couldn't quite make it work, maybe a bit stubborn.
Definitely stubborn. But he had that vision, that really radical idea for the time. Not just another car, but this car. Affordable, reliable.
A car for the masses, not just the mansion crowd.
Exactly. A utility, not a luxury toy.
And he wasn't just talking about it. His early cars, like the Model A, the Model N, they were designed from the ground up to be cheaper. He was clearly targeting that everyday American market that Alum basically ignored, or rather wanted to control through high prices and licensing.
Oh, Alum noticed him all right. When Ford actually applied to join their association, you had to be licensed by them, remember?
They turned him down.
Flat out rejected him. But it was worse than that. They didn't just say no, they actively tried to crush him. They sent out warnings to car dealers, to part suppliers, saying, don't work with Ford. He's infringing the Selden patent. You'll get sued too.
Wow, a full-on blacklist campaign.
Absolutely. They saw him as a fundamental threat to their control, to their entire royalty stream. They wanted to snuff him out early.
But Ford, Ford wasn't the type to just roll over, was he?
Not even close. He basically looked at LM's threats and fired right back. He issued this incredibly bold public statement.
What did it say?
He declared, and this really sums up his attitude, "We do not propose to pay royalties to Mr. Selden for the use of an idea that did not originate with him."
Boom. That's not backing down. That's throwing down the gauntlet.
Precisely. He was basically saying, your patent isn't legitimate and I'm not paying. That set the stage for a massive legal war.
And that war officially kicked off in the courts in 1909. The case name says it all. Electric vehicle company who owned the patent rights versus Henry Ford. It became huge news.
Oh, absolutely. ALM went all in. Their lawyers argued that Selden's patent was the bedrock invention. They claimed it covered every car powered by gasoline, no matter the specific engine design. They painted Selden as the father of the automobile.
They wanted a really broad interpretation then. Anything with an internal combustion engine falls under Selden.
Exactly. A win for them would mean total, undisputed control. Forever, basically.
So how did Ford fight back against that? It sounds pretty comprehensive.
Ford's lawyers were clever. They focused on the technical details.
Yeah.
They essentially argued that Selden's patent described, well, junk.
Junk.
Yes, specifically it described a two-stroke engine design based on the Brayton cycle.
Yeah.
And by the early 1900s, that design was basically useless for practical cars. Nobody was building them like that.
So what was Ford using?
Ford, like most successful car makers then, was using a completely different engine type.
Yeah.
The four-stroke Otto cycle engine. Much more efficient, much more practical.
So the argument was Selden might have patented something, but it's not the thing we're actually using to build cars.
Precisely. That technical distinction was the absolute core of Ford's defense. It aimed to show non-infringement, even if the patent itself was technically valid.
The trial itself must have been fascinating, the public reaction.
Huge public interest. It played out perfectly in the newspapers as this little guy versus the big trust story. Everyone loves an underdog, right?
Definitely. But the first round didn't go Ford's way, did it?
No, it was a massive blow, a real gut punch. The court actually sided with ALM, ruled the Selden patent was valid, and that Ford was infringing.
Ouch. For most people, that would be game over. Pack it up, pay the royalties, or shut down.
You'd think so. But this is Henry Ford we're talking about. Defeat wasn't really in his vocabulary.
So what does he do? Just refuse to accept it?
He didn't just refuse. Like you said earlier, he doubled down, instantly filed an appeal.
What drove that? Just pure stubbornness, or did he see something else?
I think it was a mix. Stubbornness, absolutely, but also a deep conviction that Ellen was wrong, that they were holding back progress, holding back his vision of cars for everyone. And maybe, just maybe, a shrewd sense that the fight itself was valuable. He wasn't just fighting a legal case. He was fighting for his dream, and he knew how to connect that to the public.
So while the appeal is slowly working its way through the courts, Ford doesn't just sit tight. He does something game-changing.
He drops a bomb on the auto industry. In 1908, remember, even before that first court loss, he introduces the Model T.
The Tin Lizzie.
The Tin Lizzie. And this wasn't just an improvement. It was a fundamental shift. It was cheap, radically cheap for the time. But it was also tough. Simple to drive, simple to fix. You didn't need specialist skills. A farmer out in the middle of nowhere could keep it running.
So it wasn't just affordable transport, it was accessible technology.
Exactly. He wasn't just selling metal and wheels. He was selling independence. Freedom of movement for ordinary people who'd never dreamed of owning a car. It was a direct challenge to LM's high-priced exclusive model.
And somehow, he used the ongoing legal battle with ALM as well as marketing. How did that work?
It was brilliant, really. He framed the whole thing brilliantly in the press.
How so?
He painted ALM as these greedy monopolists, this trust, trying to keep cars expensive and out of reach of the common man. And who was fighting them? Henry Ford, champion of the people.
And the public bought it.
Hook, line, and sinker. People loved Ford. They saw him as their guy, taking on the fat cats. ALM's lawsuits just made them look like bullies trying to stop progress.
So the legal fight almost became a public relations victory for Ford even before the appeal was decided.
Absolutely. It generated huge public sympathy and support for Ford and, by extension, for the Model T, a masterclass in shaping the narrative.
Okay, so the appeal process grinds on for 2 years after that initial defeat. The tension must have been incredible. Then, January 1911. The decision comes down.
Yes, the moment of truth from the Court of Appeals and the ruling. It was fascinatingly nuanced.
Nuanced how? Did they overturn the first ruling completely?
Not exactly. The judges actually agreed that, technically speaking, Selden's patent was valid.
Oh, so Ford lost again.
No. Because here's the crucial part. The genius of Ford's defense paying off. The court said the patent was valid, but it only covered the specific type of engine Selden had described way back in his original 1879 application.
The outdated two-stroke junk engine.
Exactly. The one nobody, especially Ford, was using anymore. By 1911, that design was ancient history in the fast-moving auto world.
So the patent's valid, but it doesn't apply to Ford's cars.
Precisely. The court declared Ford's cars, running on the different auto cycle engine, were not infringing the Selden patent. Ford was off the hook.
Wow.
Yeah.
So Selden's patent lived, but it was basically neutered. It couldn't touch the modern car industry.
You got it. Alem's power source just vanished overnight. Their entire monopoly was built on making everyone pay for any gas engine. Suddenly, their patent only covered an engine nobody used.
What happened to Alem then?
It just collapsed, almost immediately. Their whole reason for existing, that broad control, was gone. The Selden patent went from being this terrifying weapon to just a footnote in history books.
So Ford won, not by killing the patent, but by shrinking its power down to nothing.
Exactly. It was a strategic masterstroke, legally and publicly. When you zoom out, it's this incredible example of how innovation and, frankly, sheer defiance can overcome what looks like an unbeatable legal barrier.
So what were the immediate consequences? What did this mean for car making in America?
It was like throwing open the floodgates. Suddenly, anyone with a good idea and some capital could start building cars without fearing a massive lawsuit from LM.
So more competition.
Way more competition.
Right.
And more innovation. New companies jumped in, trying different designs, different approaches. The industry exploded.
And Ford himself, now totally free from the Selden threat.
He unleashed the full power of his vision. Mass production kicked into high gear. The assembly line.
Churning out Model Ts.
Millions of them. Affordable, reliable cars pouring out of Detroit. By the 1920s, America was well and truly becoming a nation on wheels, largely thanks to Ford winning this fight.
It's incredible. He didn't just win a court case. He literally changed the landscape of the country.
Absolutely. And he established a powerful principle. Patents should be about protecting real, tangible innovation, the kind that moves things forward, not just about locking down a whole area of technology to stifle everyone else. And maybe most importantly, he showed that one determined person, one stubborn outsider with a big idea, could actually take on the established powers, the big boys, and win.
So looking back, this whole Ford versus Alem saga, it really wasn't just about cars or engines, was it? It was deeper than that. It was a fundamental clash of ideas. Ford wanted technology for everyone. LM wanted to control it, keep it exclusive. And the guy from the Detroit workshop, the outsider, he basically smashed the gates open and let everyone in, put the world on wheels, like you said.
Yeah, and the lessons from that are still so relevant, aren't they? We see similar struggles today with new technologies constantly emerging. It really makes you think, how do we make sure our legal systems, our patent laws, actually encourage the next Henry Ford, the next wave of real innovation? How do we stop them from being misused, maybe, by clever opportunists just looking to block progress or build monopolies?
It's a constant balancing act.
It is. And what's our role in that as people who use technology as citizens? Do we have a responsibility to support the innovators, maybe question the monopolies? This story, Ford versus Allen, it's a powerful reminder that the fight to make innovation accessible, to get new ideas out there for everyone, well, that fight is never really over. It just changes shape.